most respected Swamijis of the Ramakrishna order, Dr. Balasubramaniam, his colleagues, very respected and distinguished members of the audience. I start for the first time with a sense of intimidation, the eminence of the persons assembled here, that I have the good fortune to share with you in the next 40 minutes. The lessons that I have learned through my experiences of wading through the wilderness of life's problems. The topic today, that great morning star of India's spiritual renaissance, Swami Vivekananda. His own advent into this world, his life's work was something of a divine ordinance. The latter part of the 19th century, after the exploits of a few British tradesmen in organizing a big movement to trounce the might of the Mughal Empire, a handful of tradesmen came, built their own base in India, and the prowess of their military might, which trounced what was considered the invincible Mughal Empire and Mughal might, suddenly changed the attitudes of many of our countrymen. They thought there must be something very special about the British and the English, their language, their attire, their food. There must be something superior in it, that they could achieve what the Hindu community in India thought was never possible, to get over the might of the Mughal Empire. So naturally, all that the British did, their ways of life, their attitudes, their language, their deportment, their attire, all of them fascinated the Indian mind. Yes, just at that time, as a matter of redemption of India, Swami Vivekananda entered on the spiritual scene of India. We have our own doubts whether we have deserved him, whether we have been true to that great spiritual giant and his message for us. Ladies and gentlemen, today I'm asked to speak on judicial reforms. I think this kind of a partial and shadowy examination of our predicament may not be appropriate. I think what is needed is reforms in our society, reforms of ourselves first. A country which is confused, people who are confounded, think of holding on to some slogans. Judicial reform, electoral reforms, political party reforms, social reform. I'm afraid we do ourselves no service by thinking that any of these matters individually, which are compartmentalized, and we take a partial view of the problem, will ever help us. There are 4 very, very important institutions of our national life. The very first is our parliaments, our law-making bodies. In fact, I had the privilege of chairing a commission to examine the working of the Indian Constitution over a period of 50 years of its practical application. It took us nostalgically back to the days when the Constituent Assembly debated what kind of constitution India needed and it wanted. They were meeting, as you know, at a time there's a communal carnage that was going on in the country. We had killed almost 7 to 8 lakh people in the communal uprising. The partition took its toll, and everybody was simply staggered at the level of cruelty that both communities exhibited. And during that time, the debates in the Constituent Assembly as to what kind of constitution we should have rose to spiritual heights. Some of the members, they were not influenced by the immediate experience to which they were exposed. They thought of the future. They thought that the posterity must be saved from the scourge of communal violence. And that was the predominant theme of the debate in the Constituent Assembly. As all of you know, the Constitution itself was patterned after the 1935 Government of India Act, excepting for 2 chapters, the Part 3 and Part 4, substantially the same statute. The 1935 Government of India Act was substantially adopted by the constitution makers, except for the fundamental rights chapter and the chapter on our guidelines for development, the Part 4. They were called the Directive Principles of State Policy. Traditionally, a parliamentary democracy has 3 wings: the legislature, the executive, and the judiciary. In the Westminster model of parliamentary democracy, there is no watertight compartment between the legislature and the executive as it exists in the presidential system. In the presidential system, the executive, the legislature, and the judiciary are almost watertight compartments, each independent and sovereign in its own sphere. In the case of a parliamentary democracy of the Westminster model, which we followed in India, and that's why one of our judges so beautifully put it in a fluvial metaphor. He said the Indian presidency, speaking of the President of India, he said it is not the Potomac, but the Thames that fertilizes the flow of the Yamuna. That is, we follow the British model, where the President is a figurehead, unlike the American model, where he is the executive head. In a presidential system, as I said, there is a watertight compartmentalization of the 3 wings of government. But in a parliamentary system, we have a fusion between the executive and the legislature. The legislature elects the political executive and the Prime Minister. The wonderful part of it is, in England they say, the pivot of the whole system is the cabinet. They say it is the hyphen that joins and the buckle that fastens the two wings of government. One is the legislature, the other is the executive. Prime Minister is the symbol of this union. He holds the most important position in a parliamentary system. In England it is said that he is a strange animal. He is a creature who can destroy his own creators. The Parliament elects him. Parliament elects the Prime Minister. The Prime Minister is a creature of Parliament. But they say, even if he is a minority in England, he can recommend the dissolution of the Parliament itself. And so goes the saying that this strange animal can devour its own creators. In India, the position is a little different. Under the constitutional dispensation, the Prime Minister, who is in a minority, cannot recommend dissolution of the Parliament itself. The position of the judiciary, you can't assess it except in the context of its time. You must understand the system that we have adopted. It's called the common law system. A common law system in England is supposed to be the accumulated wisdom of judges over centuries. They have built these institutions case by case and responded to the needs of time and built up a system which is called the common law system. It doesn't have one source. It has one continuous stream of wisdom as to how social issues should be handled. There's an extraordinary system which is a kind of an architecture which is enduring, but it's not indestructible. And such a system requires great discipline to work. Today, the Parliament, the judiciary, the political executive, the permanent civil services, and more than anything else, the culture of obedience to law in this country are all matters of great concern. For example, you have the political system. In fact, in one of the papers in an organization which I had, we released the most urgent requirement is the form of political party, the formation of political parties, their internal democracy, their funding, the transparency of their accounts, and making their accounts public, and the need for a control under a legal regime of the behavior of political parties, of dynastic politics, which is anti-democratic. We, in fact, in an institution called this Center for Standards in Public Life, of which I am currently the chairman, we released that paper for public debate. We said that today, out of 1,200 political parties in this country, hardly 90 of them participate in any kind of political discourse or electoral business. The rest of them are parties for namesake. In 2004, they were all given exemption from income tax for the donations they received. And very interestingly, the Election Commission published a report in which they said, excepting the mainstream political parties which participate in electoral business, Many of the others, their essential purchases out of the donation were jewelry and saris. They were not in any way related to political activity. In 2004, the income tax exemption came in handy for them. And one registered office of a political party was in a tea shop. The other was in a grocery store. And rightly, these things have happened. But one thing we must understand, and that's where I place great stress. A country with such great diversity, it is not one country as we could reckon geographically. It was a subcontinent with such a diversity of languages, cultures, creed, and even physical features. We have the Mongolian features, we have the Dravidian features, we have the Nordic blondes, we have the Punjabis, and such wide variety of people, languages, creeds, dialects. To combine them into within one common bond of constitutional justice was an act of great vision. They have built it with a great amount of patience, and I'm amazed at the way they achieved what was almost impossible. The diversity was so intense that even a small matter, like perhaps one of the instances, the right of a person professing the Sikh faith to carry a kripan, had to be accommodated expressly in the constitutional document in Part 3. Look at the kind of range of issues that they had to handle. And one person who asserted, a person professing a Sikh faith, he wanted to bring a big sword into the courtroom. And he said, this is my constitutional right to carry a sword, a kripan. And the issue was whether the security of the courtroom prevailed on the constitutional right of the Sikh person, the person professing the Sikh faith, to carry his sword everywhere. These are issues which come up with a dramatic impact on the minds of people. The importance of the judiciary is that it is a final arbiter of the constitutional issues. Many of our judgments in the judiciary have run against the popular sentiment of people, run against their common approbation. But still, with all the faults of the judiciary, people still believe that their constitutional and fundamental rights are safe in the hands of the federal judiciary, the Supreme Court and the High Courts. It is something unbelievable that what they did. In fact, I give you a small instance where in the old days before the Constitution, there were 3 English judges in the Calcutta High Court. The Criminal Procedure Code had a provision which said if a man was illegally detained, the court can issue a writ of habeas corpus, a famous traditional writ issued by the common law courts in England. And that was confined to metropolitan area. The power of the court was confined only to the metropolitan area. When Amir Khan was arrested outside the metropolitan area, he approached the Calcutta High Court. He said, look here, police have taken me into custody against law. Government said the court's jurisdiction doesn't extend beyond the metropolitan limits of Calcutta. That's Article Section 491 of the old Criminal Procedure Code. You can't issue a writ. 3 English judges said, look here, you have read the law wrong. We don't inherit jurisdiction from the Criminal Procedure Code. It is the Charter of the Queen that established the Presidency High Court of Calcutta. That charter says we have the power of the Court of Common Pleas in England, and that court had the inherent power to issue a writ of habeas corpus. So, notwithstanding the limitation in our section 491 of the Code of Criminal Procedure, we have the inherent right to exercise this jurisdiction. And that was the famous Amir Khan's case way back, long before the Constitution was born. Same issue came up again in the Madras High Court. Judges again said that this law won't limit us. No prescription really can raise above the conscience of mankind. That's how the basic approach to the issue was formulated. The history of the Indian judiciary has been a splendid story, notwithstanding some aberrations here and there. And the judicial system in this country is modeled on the English common law system, where the judge is traditionally supposed to be a mere umpire. Something like in cricket, the common concept of the role of a judge in a common law adversarial system, as against what is called the inquisitorial system of the European courts, where the judge himself gets into the truth of the matter, he gets into the ring and covers himself with the dust of the fight. And that system in Europe is lauded because the judge gets into the truth of the matter. Here, it is not the truth, it is the evidence that we rely upon. In the common law system, it goes on the basis of evidence, not on the basis of truth. It's not a search for truth as people necessarily expect courts to go into. But the philosophy on which this common law system of adversarial jurisdiction is based is that when two persons appear in court, aided by expert men in law, if both sides tell falsehood, truth has a knack of peeping out of the situation. And that requires a very, very able judge to see through the game. It's a very fascinating story of Indian judicial system. People think that the unfortunate thing is, in its administration, we have got into some problems. In India, we have 30 million cases pending in these subordinate courts, apart from the high courts. 30 million cases. 19 million cases are criminal cases. 11 million are civil cases. And out of these 30 million, 52% of these cases are just in 5 states out of 27 states. 5 states have 52% of the pendency of this. So when you bring in reforms, one size doesn't suit all. You'll have to tailor the remedial reformist measures according to the requirements of each district, perhaps each court. A general thumb rule of enhancing judge strength, irrespective of the requirements of the local courts, will become a little unrealistic. As a matter of fact, Supreme Court some time ago said, oh, we have about 11 judges per million population, while Japan has 150 judges per million population, and enhance it 5 times at least. Some wag who was accustomed to criticize the judicial system, he said, what a perverse thing it is. Why do you want so many judges per million population? Why not per million crores in the country? You must have number of judges related to number of cases, not human beings. Most of them have nothing to do with the courts. They have nothing to litigate about. They're so poor that their own daily existence is their problem. They have no property, no rights. Nobody bothers about them. Why do you take this into consideration? And he very cynically said, this prescription is something like ordering opening of new graveyards in anticipation of an epidemic. something he said that to anticipate an epidemic and then prepare yourself for opening more graveyards. Of course, he didn't openly say that courts are graveyards for justice, but he almost came near to it. But ladies and gentlemen, the issue that I want to make out is that courts are in dire need of some kind of a sensible way of working. We have hundreds of cases pending in courts. Judges are most hardworking, don't have a wrong impression about them. If they have 2 months of holiday, people shout, oh, the superior court judges have 2 months holidays and we can't afford it. I also believed in the same thing, and when I was Chief Justice, I requested my judges to enhance the working days by 24 days in the year. And they worked half an hour more every day. And that's the most splendid experience that I've had in my 62 years of contact with the judiciary. And I must tell you one thing, the way in 1991 I was not Chief Justice, I became Chief Justice in 93. Mr. Palkhiwala was a very eminent Indian, a great lawyer. He, out of sheer frustration, said, this institution, this wretched institution, the Supreme Court of India, would need 300 years to cleanse its own mess. He didn't say wretched institution, but he meant it. Oh, the judges were all agog, and they said, this is a very wrong statement for a lawyer or an insider to make. The judges met, and I said, Palkhiwala made this statement out of affection for the institution, out of his concern for the institution. And the stringency of his remark conveyed the intensity of that concern. He had nothing to do with the courts, he wouldn't have talked about us. He had much to do with us, and he had much to feel for us. And we should receive this with some amount of respect. And they asked me, you be in charge of the case flow management to the court. That was 2 years before. I said, the master of the roster is the Chief Justice of India. Nobody else can handle that. But they said, at least on his behalf, you administer the court, the case flow management, not the judicial side, the registry. Then, very interesting thing happened. I found that there were 187,000 cases that were pending on that day. When I was asked to look into the functioning of the registry. Between 1991 and 1988, for the 8 years, we added another 365,000 cases and an average of 44,000 cases per year. We had to account during that year with an opening balance of 1,87,000 cases and 3,66,000 cases. We had to account for about 5,48,000 or so, I'm not very sure of the figure, for the period of 8 years. This period consisted of my own term and my immediate successor, Chief Justice Ahmadi, a great manager of court, and Justice Verma, my very dear friend, who was Chief Justice for a term of a year or so. Amongst the three of us, we ensured that at the end of the period, on the 15th or 16th of February 1998, the whole Supreme Court had just 16,000 cases, as against 5,45,000 that we had to account for. I'm mentioning this not as any personal achievement of the three of us, not at all. But given the proper scientific method of management, it's too serious a matter to be left alone to the judges or lawyers. Today, it is the systems men in computer systems. They are the essential kingpins of this work. This is the most important aspect of management, to bring into it a scientific view of of the science of management, what they call supply chain management, where you have handle the cases, assess the manpower requirements, and train them, and put them into a stream. It is simply possible because India is under-litigated. People have a wrong notion. There is a docket explosion in this country. There is no such thing. It is a docket exclusion, if anything at all. In the United States of America, for every 1,000 population, 388 new cases are filed and decided every year. Every year, 1,000 people bring in 388 actions, and they are all decided. In Singapore, that number is 89. In Singapore, the number is 89. Why is this difference? The per capita income in Singapore is as much as in the United States. The literacy levels are almost the same. Given both these parameters, why is there this change of assertion of rights? Simple fact is, United States of America is an open society. Singapore is a closed society. The great leader of maker of modern Singapore, Lee Kuan Yew, he made a very controversial statement. He said, if you want development, forget democracy. If you have democracy, you will never have development. This is the famous Lee thesis in economics. But contrary to this famous statement, out of the 49 rich countries in the world, 43 are democracies. 43 are democracies. And in fact, out of 49 high-income countries in the world, 19 countries have populations between 1 to 10 million. For example, Finland has just 5 million population. You drive in the streets, you will see nobody there in the streets, particularly in winter. There are no people at all. And the great human capital this country has, as many developing countries have, is simply thrown waste. And they can build beautiful edifices of achievement. And that requires a great leadership and imagination of involving everyone, every human being born into this world is a part of the human family and has his rightful place under the sun. The judicial system, what it needs is a proper planning of its work, a disciplined combination of scientific methods of management and skills of adjudication. The art of adjudication is a beautiful thing. The cross-examination is another beautiful thing. It's all one of the most a falsehood uttered in court is put through the fire of oral cross-examination. You must see the beauty of the cross-examiner's skill. In fact, there used to be told a story of Sir Patrick Hastings, a great criminal lawyer in England, and he was engaged for an insurance company where an old woman came and said, in an accident, it's a personal injury action as they call it, she came and malingered before the judge, saying that I can't lift my hand after the accident, I can lift only up this much. It is generally said, a long face is a passport for a big award in court. Of course, in America, it's a scandalous kind of thing. After all, the American tort system is to be seen as the height of absurdity in any legal system. In fact, it is said that a lady was driving a Porsche car with a boyfriend next to her. And she had perhaps a drink too many. And she went and hit a tree, and the boy died in the accident. Then the liability came to be fixed on the manufacturer of the motor vehicle, that they had designed too high performance a car for a lady to drive. Therefore, on the basis of product liability, that boy's compensation must be paid by this thing. A thief went on a school building, not the Ramakrishna Mission, and there is a skylight, a glass sheet. He stepped on it. He went there obviously to commit theft. Of course, it happened in America. He fell down through the glass sheet, and the school was held liable to pay him compensation, for they should have anticipated a thief would come, and that he fell down to the, I think this is exactly what when I inaugurated the Indo-US Legal Forum, I was asked to speak about the American system. I said, I think we'll wait for the further heights of absurdity of the American system. And of course, it's you can't compare the American system here. And that was the point I wish to say is, while for 1,000 population, 89 cases are filed in Singapore, 388 in the United States of America. In India, it is 29 in the state of Kerala and 4 in the state of Jharkhand. And when people say that we must settle all these things by mediation and negotiation, arbitration and settlements, the chill goes through my spine. We have to build a right-based society. A breach of a right must be pushed to its logical conclusions. You can't make charity a substitute for justice. There are some cases which need to be arbitrated, settled outside court, or pre-litigation settlement, or a pre-trial settlement, and things like that. In the Western countries, 75 to 80% of all cases are settled before the trial commences. Pre-trial or pre-litigation settlements. Only 15% or 20% of the cases go for the most costly procedure of trials. In India, almost 85% of the cases go for trial. Hardly 10% are settled outside court. That's an absurd situation the other way. But to say that every breach of law, breach of justice, should be settled by compensation, not by a legal verdict, is a wrong thing. We will not be building a right-based society. A right-based society requires that a man should come to court and say, well, my right has been violated or abused by the state or by my neighbor. It may be anybody. It may be a butcher or the baker or the candlestick maker. Anybody who's outraged of his rights must be able to come and say, I demand justice. I demand justice. This is what is said of a great king's court in our legends. A cow came and rang the bell of a king and said somebody had trampled upon its young ones. The king said, I was the one who drove that, and I killed this animal. And he told his Minister of Justice, cut off my head. They said, no, the nation has to suffer for it. And then a compensation was made in an appropriate way. When justice is said, I remember the name of one, Ibrahim Zubairi, who was Minister of Law in one of the, under an Islamic ruler in a state. He was, as Minister of Justice, he was also the judge. And one day, when he was eating his food, he asked his wife, this food smells of corruption to me. This innate sense of propriety of a judge who lives a moral, clean life, that's the test. The wife said, my lord, I brought the vegetables myself, I cooked the vegetables myself, and I'm serving you. He said, tell me what happened since morning. He said, oh yes, when I was peeling the vegetables, an old woman came, sat next to me. She wanted me to intercede on behalf of our son who had been arraigned before you in a case. Then he asked, what did she do when she was sitting? Oh, she also peeled the vegetables. he said, that's why I say this smacks of corruption. And he pushed the food aside. He's a Muslim potentate's law minister. His name is Ibrahim Zubairi, near Bijapur. In one of his, I tell my judicial officers, if you want to go to a pilgrimage as judges, go there and offer your obeisance to that, the mortal remains of that man. When his own son was arraigned before him for having misbehaved with a woman, with a lady, he ordered him to be punished with 99 lashes. At the 97th lash, the boy died. As a dutiful father, he took the mortal remains of that boy, interred it, and administered the last 2 lashes on the grave himself. That as a father, he did that. If you have no sense of commitment to justice, it's not trickery. If you are not a judge inside you as a conscientious human being, entrusted with this task of administering justice, keeping peace amongst people, you are not worthy of occupying that place. If you don't have that, you simply don't have it. Don't be, as Tolstoy once told the politicians, if you don't have an impersonal love for mankind, don't pretend to be leaders of men. If you pretend, you will soon be found out. And occupy yourself in some trade which is gainful, make money, enjoy life, but don't be leaders of men. Judges are leaders of men in a moral sense. It's an expression. It's an expression of moral defeat. It's an equivalent to a moral defeat to say that I can think otherwise than a pure conscientious judge. The role of the judge is that. And ladies and gentlemen, today, if you speak this language in an American audience, they will think you are a freak. You speak of Vivekananda and his values, somewhere deep inside that troubles them. Well, there is something in what this great saint and servant and Messiah said, but immediately they get over it. And there is always, if there is any troubled conscience in the day of what you do, there is a remedy in the evening. You have a glass of whiskey, which will drown all your guilt, dissolve your guilt in this. The whole world is moving at this space. Democracy has now become a mere statistical interpretation of democracy, of large numbers. Whoever commands large numbers, you buy votes. District can do more than all the judges in the world can do for those immediately under him. A good deputy commissioner of a district, a collector of a district can be the symbol of great justice to people for their redressal, immediate redressal. When I said people with a population of 1 million have their own country, their own prime minister, their own parliament, access to institutions of redressal of grievance are immediate. And that gives them a sense of assurance that they live under a protected system. Today, when Tom Paine wrote that famous book, Rights of Man, he told his king, you can't inherit people as if they were goat and sheep that your father reared and you are inheriting them. You can't inherit people. He was arraigned for treason. No lawyer was prepared to defend him for fear of royal retaliation. The Attorney General of England was a great friend of the king himself, Erskine. He wrote to the king, his friend, this is not tolerable to me. I'll resign and defend him. I'll resign and defend him. He did so. Of course, with what result all of us know. Tom Paine's book, Rights of Man, became a symbol of great human dignity. This happened in a case of an American judge. There's a very brilliant judge, William Douglas, who was 40 years judge of the American Supreme Court. Nixon had a grievance against him. He started an inquiry, impeachment of Douglas. This man was beleaguered. This great judge was beleaguered. He went to the Attorney General. Edwin Macy was the Attorney General. He asked him, if this is what your president is doing to me. He said, I can't do anything. You have to defend yourself. Somehow, somewhere, Nixon developed cold feet, and the whole thing petered out. Douglas didn't know why this happened. Later on, long thereafter, a young lawyer from California, whose father was an earlier judge of the American Supreme Court, his name was Hugo Black, he was a Jewish judge. That boy came and said, in the heat of the impeachment movement, my father wrote a letter to President Nixon. Here is a copy of it. That letter said, Mr. Nixon, Bill is an honest man. If you or your henchmen try to lay hands on him, I want to let you know there is one last trial left in me. There's one last trial left in me. I'll resign and defend him. That did the trick. And Hugo Black was a very influential judge, a great judge. Nixon retraced his steps. That was the kind of bonhomie and brotherhood in the defense of justice. And this system we have brought in has to be nourished. See, today there is a hankering of reforms. Reform must start with us, within each one of us. Every night before you go to bed, 2 minutes, you just ask yourself, just simply ask yourself whether what I did today, what I uttered, what I spoke, what I thought, what I did was demoniacal or angelic or human. It was a sattvic thing or a rajas thing or a tamasic thing. And back comes the answer. The all-pervading, the universal, impersonal antaryam in each human being is ready to give an answer instantly. You don't have to file a plaint, argue, take a lawyer and argue before your conscience. The conscience comes back immediately. A judge has to ask himself this question. The only thing is the way in which this is exactly where there's a beautiful passage of a dialogue between Devahuti and Kapila Muni. Kapila Muni was supposed to be the very incarnation of Narayana himself. The mother addresses the son as Prabhu. My Lord, how do we worship? He says, I am present as the indwelling impersonal divinity in every human being. And if you don't worship me there and come to me with presents and gold and ornaments, I won't accept it. Unless this principle of conscience inside a man, that the very reflection of God, reflection of divinity, if we don't understand, make it the rule in all our aspects of life, judiciary, legislature, administration, in whatever way you think of being a part of this society, I think things will go wrong. But judicial reforms are the urgent need today. And Monday I am asked to go and attend a meeting. The law minister has requested me to be a part of a group to suggest something. I think in the wake of what is happening to Asia, the emergence and rise of Asia, today, if you take the parity of purchasing power, GDP, India and China, their GDP today, combined GDP in terms of PPP as they call it, parity of purchasing power, is higher than both United States and Europe put together. This is the indication of what is going to happen. This is the rise of Asia. And when you find in the course of the next 10 years, 20 years, China, India, Japan, South Korea and Indonesia, these 5 countries will be at the top of the world in economic terms. China has built its might through the factory. It's the factory of the world. India has built its prosperity not on the raw muscle of the factory, but on its brain power. The backroom planning, outsourcing, the business process outsourcing, and their intellectual effort. And I think we are looking ahead for a brilliant millennium. Next 10, 20 years will be beautiful years. It will be years of great change. But the change in India must start with each one of us, and that is the message of Swami Vivekananda, that you reform yourself, be a good moral human being, and everything will change for the better. Thank you very much for your patience and trust.